Having made this brief presentation, I will leave the floor to my colleague Alisa Pestryakova, who will start her presentation on a commercial agreement. Please, Alisa, go ahead. Thank you.
Thank you, Armando, for giving me the floor. And as you told, I'll be speaking about the impact of COVID on commercial matters, and especially how it is working with the concept of force majeure. We start with the presentation. I hope you all see it. Force majeure in connection with COVID-19. So this question question of force majeure has arisen not in connection with COVID, of course. The concept itself is well known and in all the jurisdictions, I'm sure, and of course in Russian law as well. What Russian law says about the force majeure. The concept is in the law, but there is no special description or notion provided in the law. What Russian law, and especially civil code of the Russian Federation, includes is the idea of the force majeure. It's Article 401 that says that the person non-performed or unduly performed its obligation in business operations is held liable unless he proves that yearly performance was impossible due to force majeure, meaning circumstances which are extraordinary and unavoidable under the current situation, which gives us some kind of understanding what's lower thinks of force majeure, or what is an idea of it for the Russian law perspective. We see two main points there: extraordinariness, which means that there is something happening that you can never avoid or can never expect to happen, and cannot predict in any way, and not only by someone, by some entity or person acting on the market, but by any person acting on the market. The second idea is inevitableness, which means, of course, I'm sure you're all quite familiar with the general concept, and I think Russian law is in line with everyone else's understanding that this means that you can't avoid the circumstance which you name force majeure, and you cannot not only predict, but also to avoid and to any way to pass by or to not to be affected. This idea was also supported by by courts, and of course, Russian Supreme Court in one of its decisions explained the notion of extraordinariness and inevitableness, saying that this should be and understand as external circumstance, not some objective circumstance, not subjective to some specific person, but applicable to anyone being in the same situation, on the same market, in the same circumstances, which is beyond the will or influence of the person affected by these circumstances, and that are not able to be not only avoided, but also predicted and foreseen in any way. And what is important, that both extraordinariness and inevitableness should be in one, jointly affecting the circumstance and the the applications of the party, not only one of these. It is just the understanding, but it doesn't mean, of course, that any person who thinks or sees something happening in his operations as force majeure can just say that it is and benefit from being not liable for non-performance. It is the court who takes the decision and assesses all the circumstances in particular situation and decides if force majeure has happened in respect of particular obligation. And it, of course, is based on some dispute happening in court between the parties on commercial issues, on if one of the parties claiming non-performance or some other question arises. The court is looking at all details, and first of all, they're looking at the clause of force majeure if there is something stated in the agreement, and looks for statutory provisions, which we have discussed above. If the party has not included force majeure clause in the agreement, it's only statutory provisions that will be taken in account. So it is important. It's mainly quite standard wording, but I think nowadays it's obvious that it's important to be included in the commercial agreements and stated some details, not just plain words and usual wording, because parties can agree some circumstances to be considered force majeure for them, for this very obligation, for this very agreement and situation. The party who's claiming exemption from liability and due to force majeure and claiming force majeure need to provide to the court documented proof, and it means directly. We need to understand it directly that it needs to be documented. Written proof, especially for Russian court, they would like to see some written documents, something official to confirm that the circumstance was extraordinary and unavoidable. And of course, the party needs to also to show and to prove that not only the circumstance has happened, but this directly affected his ability to perform, his or her ability to perform the obligations, and that these circumstances was really the reason for non-performance. What are documented proof? What can be provided? For international operations, for international agreements, and Russian internal contracts, the documents can be different. The Chamber of Industry and Commerce of the Russian Federation, its main office situated in Moscow, is providing special documents, certificate of force majeure, which can be considered a proof of force majeure. Usual examples that we all know from the standard wording of force majeure texts, clauses, it's natural disasters, strikes, military operations, and all other stuff. Of course, it's not includes business risks if this is not stated directly in the contract between the parties. The Chamber of Industry and Commerce looks for the documents. They are not certifying just the fact of happening some situation, but they are given the certificate stating that their view is that to this very contract, the situation that has happened can be considered a force majeure that was extraordinary and inevitable. So they are assessing and looking at the documents, at the contract, maybe some other provided documents by the parties, and giving their opinion, providing a certificate. For local operations, the local branches of Chamber of Industry and Commerce provide also it's named the certificate of force majeure, but it's another document. And they also, together with the application for obtaining force majeure certificate, the party needs to provide a copy of the contract and some documents certifying, approving the facts that they would like to, what they consider prevent them from duly performing their obligations. It can be, for example, some notice from local weather agency that there was some disaster or something else, or a document of local authority, for example, introducing or enacting situation of emergency. And based on these very documents and together with the information and details of the contract itself, the Chamber of Industry and Commerce decides and gives its opinion and may issue a certificate of force majeure. During 2020, by the mid-year, the Chamber of Industry and Commerce reported that there was a 7-fold increase of number of applications for force majeure certificates, but taking into account the internal contracts, it was 95% of rejections of applications, which means that it's not that easy to show and to get this certificate because as we told, this is the assessment of the chamber if the exact situation can be considered a force majeure. And saying this, we should say that these certificates are only one of the documents that can prove the force majeure before the court. Yeah, here we are. This is the right slide, sorry. And it is only one of the evidences that can be provided to the court by the party to prove that force majeure circumstances has happened and that these circumstances prevented them from performing its obligations. And the certificate of force majeure, you need to understand, does not guarantee release from liability, and that you need to provide as much documents, as much proof as you can. It can be documents for public authorities, some acts, official acts, or information from some public agencies referring to the certain facts and confirming certain facts, because it's not the work of the court to investigate the details. The party should provide all the proofs in support of its position. Coming back to 2020 and COVID-19 situation, we should ask ourselves whether the situation of pandemic is exactly the situation of force majeure. And it is, we should mention here that in Russia especially, apart from many other countries, in Europe especially, as far as I know, state of emergency was never officially declared or announced by state authorities in its proper sense. So it was only like in situation of risk of emergency or something like this. And all regions, including Moscow, introduced the kind of preliminary situation of high alert in connection with COVID, but no one have introduced a state of emergency, which can be directly considered a force majeure. And this makes the situation with non-performance of obligations in commercial contracts in Russia not very easy, and even more difficult to prove. What we may say that in the region of Moscow, Mayor of Moscow declared that COVID may be or shall be considered an extraordinary and unavoidable circumstance and considered a force majeure situation. However, this order is only, again, one of the evidences that can be provided by the party to prove its position of force majeure and claiming exemption from liability for non-performance. Per se, the order of mayor does not exempt from liability any party of the commercial contracts, of course. But this very order or any other document similar issued by any authorities may be used as an additional evidence in position in court if you need to prove force majeure circumstance. What else can be done in the situation when you suffer some restrictions in situation of COVID-19, for example, in Moscow, or international deliveries or something, to try and agree with the counterpart an additional agreement, because I guess for all the contracts that has been concluded before situation of pandemic was really ever written in the wording of force majeure clauses in the contracts. So the first step may be to try and agree some changes, postponement, or amendments to the obligations with your counterparty. What is essential, taking into account working with Russian counterparts and with the Russian market, keeping in mind that at some point you'll need to turn to court with the trying to prove your position and try to claim force majeure. You need to make all your all the agreements in a formal way, to make a formal offer in writing to your counterpart, make an offer of any changes, make in writing any notices of the special situation or any restrictions you are suffering, because only and mainly writing documents and writing offers or writing agreements will be accepted by the court as an evidence and can be helpful, useful in proving your position. If it's not possible to agree with your counterpart the change of the agreement, you can claim for sure the force majeure and the restrictions taken in connection with COVID at the court, providing evidence. And in this situation, of course, all your formal offers to your counterpart, all notices of changes, any agreements offered by you or suggested will show your good faith and your integrity and your wish to solve the situation and to work on the situation, and that you have done all your best to perform your obligations. The difficulty is, as I mentioned, that they need to be shown if you try to claim force majeure, the direct link between the circumstances you're suffering and your non-performance, inability to perform or unduly performance. Because as all of you know, most of the times the pandemic restrictions indirectly affect your working, your ability to deliver your work, or to deliver the goods, to perform your obligations, and only sometimes it can affect directly. For example, the work of restaurants was restricted and was actually all the restaurants and all the entertaining companies were closed actually during the pandemic situation in Russia, and this means that the direct effect of it was that they could not perform its obligations before the clients, for example, in arranging a party for the client or a special dinner, if this has been ordered before the situation of pandemic. But it's not applicable to non-payment, for example, of rent fees, or to pay non-payment of something else, for example, some repair works made, or payment for deliver some goods or for your supplies. Business risks, as we told, this is not a force majeure unless you agree, specially agree directly in the agreement, and Russian law allows it. If this is directly written in your contract, that some of the risks, for example, applicable and can be and should be considered a force majeure, this will work. But from statutory perspective, nothing of the list shown on the slide is force majeure. The shortage of funds, the deficiency of goods, economic crisis, insolvency of counterparts, supply failure of your suppliers, currency exchange rate fluctuations, and similar situations. Of course, it is considered that these all can be predicted and are usual risks of businessman, of any business activity. But we all understand that in the situation of pandemic, the level of effect of this, or the joint effect of all these factors, make the situation very difficult for many of business entities. However, it doesn't mean that this can be considered a force majeure. In the situation of pandemic and COVID-19, all the governments were trying to support or to make special regulation to support commercial entities in commercial area, and especially in Russia it was needed because, as I told, Russian authorities has not declared the emergency situation in any of the regions. It was only something like risk of emergency or similar, which directly cannot be considered as force majeure, of course. That is why the Russian government adopted a few special acts, one of which was resolution of Russian government issued on 3rd of April, introducing conditions and provisions for deferral of rent payments. it was a big issue that many of the companies closed, many of the restaurants, shops, having without operations, were not able to pay rent for the under their contracts. And this special act provided an option of partial deferral in such situations, and it was available for all the companies, not to the special list, for everyone who claimed the postponement of payment of rent. The other party, the lessor, was obliged to conclude the agreement in writing on postponement of payment of rent, it's applicable to 50% of monthly payment that can be paid during actually this year, 2021 and 2022 year, in equal installments, to compensate the deferral of rent payments happened during the restrictions of COVID situation in 2020. Of course, this is applicable to all the companies, as I told, but can be refused if it's obvious that the company didn't suffer any restrictions of COVID. For example, pharmacies was working and was, of course, have a good business during COVID-19, and this option of postponement of rent payments will not be applicable for them. What else was done as another example? We can say that there was a special law 98 on amending certain legislative acts. It was adopted on 1st of April 2020, and it provided a right to the companies to reduce the rent amount, rent payment. For the companies who have no opportunity to use their property. Many offices has been closed because of the restrictions, for example, in Russia and in many other regions. Restaurants has been closed, and many other companies were not able to use the property they were renting. So this law was aimed to find a solution in the difficult situation, this is an option, not an obligation, to agree the reduction of rent payment between the parties, and it should be applicable even if the parties agreed sometime during the restrictions or taken due to COVID. It should be applicable from the moment it was impossible to use the property. But there are, of course, some conditions that need to be met. This reduction of rent can be requested for a period up to 1 year. And in case the lessor has not agreed to reduce the rent payment and has not signed the offer or the additional agreement to the rent contract, the lessee may terminate the contract in a certain situation. The lessee is a small or medium-sized business. The lessee conducts activities in the affected section of the economy. And we need to mention here that the affected sectors of the economy it can be found in special lists provided by official authorities, for example, regional authorities, and these sectors or these businesses were subject also to special support of the state. And if the small and medium-sized business is working in this affected sector of economy, it can use this opportunity to negotiate and to reduce the rent or to terminate the rent contract. The other condition is that the contract has fixed term, but this is quite standard situation for Russian property, and it shouldn't be a problem. And the contract, of course, need to be concluded before the start of pandemic, before the introduction of high alert or emergency situation, meaning that if you already have known of the difficulties, but you still concluded the rent contract, then you're ready to perform your obligations and to pay the rent in the current situation. Rent fee reduction requested, as I told, for a period of up to 1 year. And in case the parties has not came to an agreement or lessor has not agreed to adapt or make it easier for the lessee to pay the rent, then the contract can be terminated. The request to lessor net to be shall be sent, and of course we should state again that it should be in writing, an official notice, and then upon expiry of 14 working days, which is almost 3 weeks, the rent contract is terminated. The last note here is that withdrawal notice should be sent by 1st of October, so it's not applicable anymore. But in case of something similar happens or the situation will be becoming worse, we may expect something similar coming again with another option for termination or for reduction of rent payments. So finally, what we can say that the usual concept of force majeure is applicable to the situation of COVID, minding that it needs to be proved at the court, not only the circumstances itself, but the direct link between the circumstances and non-performance. And in this situation, we need to carefully look at the documents you have signed or you plan to sign, and to look at the wording of force majeure clause, and try to include some COVID restrictions, pandemic restrictions into the contract if it's not concluded yet, looking for the possible solution in case of non-performance. In the situation when you already find yourself that you cannot perform duly your obligations, you need to understand what are the reasons, whether there is a direct link between the circumstances and your non-performance, whether you will be able to prove it in the court, and to have enough written evidence to support your position, and on the basis of this to decide whether you can agree or should try to agree with your counterpart some postponement of performance of obligations, or withdraw or terminate the contract. What is the best solution in your specific situation? And please don't forget that when you negotiate and come to some agreement with your counterpart on force majeure on a specific contract or on obligations, non-performance, postponement, you need to make it all in written form, in official form, execute, sign it with your counterparty, and amendments to the contract termination or official offers to them. In case something goes wrong, to have proof of your goodwill, faith, and ability to defend yourself in case of dispute at the court. So this is the end, and you're welcome to ask for the questions if I can answer you.
Thank you, Alisa, for your clear and exhaustive presentation. Let me remind that the questions can be asked through using our chat, and we will read at the end of each presentation. Myself, I have one, let's say, question for you. Let's say that the pandemic was somehow unexpected. It was a big surprise for all of us, including lawyers. Even though we study force majeure clauses and so on, it was somehow unpredictable. But you have clearly explained what happened if we have an existing contract and what we can do in order to invoke force majeure. But now let's think about the future. Let's imagine a company who is entering a contract today. So learning from, let's say, all the situation that we have had in the past, what would you suggest to a client, to a company who wants to enter into an agreement today, knowing that maybe the situation about pandemic can get worse and we have to take, let's say, in terms of the contractual means, what can we do now?
From perspective of Russian law, I would say that keeping in mind that that the Russian law accepts the force majeure as agreed by the counterparts, you should try to include the pandemic and certain restrictions, formulate that, for example, restrictions of state in connection with pandemic or mass diseases that affect the operations of commercial entities shall be considered a force majeure. In this case, you have a good point for discussion in case something goes wrong with your counterpart, because you both has been, if you write it in the contract, in the force majeure clause, it means that you have thought of it and the possible consequences that some obligations may not be fulfilled. And this will be showing your good faith start of the discussion of negotiations for amendments to your contract, to your obligations, and it will be a good point for the Russian court that this is actually a force majeure for the parties, and this will be a good excuse for held and liable for non-performance or unduly performance, for the delays, penalties, or anything of the kind, if you state it in the wording of your contract. So I would advise to add to your standard wording used in the contracts the situation of mass diseases and restrictions of state authorities to operations, including international operations, that can affect your business.
Thank you, Alisa. So I think it's a question of being careful in drafting contracts after all.